Good afternoon, ladies and gentlemen, distinguished guests and honorable speakers. Welcome to the exciting and interactive event organized jointly by Thailand Arbitration Center, the Chateau Institute of Arbitrators Thailand branch, and Clyde Co Thailand. We appreciate your attendance in the midst of your busy schedule to attend our event today. And for today's session, it is titled The Hottest Seat in International Arbitration Debates. And today's session will be moderated by Dr. Roland Amusu Genmu, partner at Vogel and Associate. Dr. Roland has over 20 years of experience in Asia. He specialized in international arbitration, ADR, OHADA, PDPA, China-Africa Cooperation, digital economy and digital asset regulation, PPPs, construction, and FDIC. Dr. Roland is also an academic and research person to professional training program, panelist at THAC, commission member at ICC Thailand and the CAIRB Bangkok branch. He has also presided over arbitration tribunals. Dr. Roland wears many other hats as co-founder and president of Asia Africa Foundation, Bridging Culture under the UNESCO Dance Council, Taekwondo Black Belt and former champion. He has diplomatic mission and is Mississippi of the King of Benin. Dr. Roland has received the African Man of the Year 2022 Asia Pacific Awards. His book, The Law and Practice of International Arbitration in Africa and International Arbitration, The Seat is King. Before leaving the floor to Dr. Roland and our panelists, I would like to remind you, our virtual attendees, that if you have any question, please write using the Q&A button. Then the question will be handed over to the speakers at the end of the seminar during the Q&A session. Thank you. Now it's time to leave the floor to Dr. Roland to give you the background information of the seat. However, before that presentation, I would like to take this opportunity invite Dr. Vanina Sucharekun give the opening remark on behalf of CAIRB Thailand branch, please.
Good evening, ladies and gentlemen. Thank you so much for being here. On behalf of the Chartered Institute of Thailand branch, I am more than delighted today for the first joint in-person collaboration with the Thailand Arbitration Center. I hope that this is a great start for future collaborations going forward. And I'm even more delighted that our event today has been broadcast and live streamed for other branch members around the world to join us. And I'm even more delighted that we have a number of committee members speaking today. And I'd like to thank Clyde Co for sponsoring our networking session. Needless to say, the seat of international arbitration is one of the most important decisions. And you will learn today as we go on a world tour from Europe to America to Asia. And I can't wait to get started. We have a wonderful moderator who just launched a book called The Seat is King. So without due delay, welcome Dr. Roland.
Thank you so much, Vanina. Ladies and gentlemen, let me first thank the MC for a very warm and engaging introduction. Your kind words truly set the tone for an enriching and exciting conversation that we're going to have this afternoon. Gentlemen, distinguished panelists, my colleagues, esteemed guests, participants, good afternoon. And thank you again for joining this event in person or virtually. It's a great honor, really, and privilege to stand before you as a moderator for the hottest seat in international arbitration debate. And as far as I remember, I think this is the first time ever such event is organized. Before we begin, I would like to reiterate our gratitude to THAC and CAIRB and to our supporting organization, Clyde Co. course, credit goes to Dr. Vanilla for her magic touch and her ability to make things happen by transforming a simple conversation we just had a few months ago into an exciting and impactful event. So this is to say, if you have any idea and you want it to manifest, talk to Dr. Vanilla because she has a magic to make things happen. Right. So, and of course, let me take this opportunity, all our respect for your dedication in spite of the recent loss in your family and your grievance. You still with us, and that is really something we appreciate. As a moderator, my duty is to be like a conductor, right? A facilitator, instigator, and sometimes a catalyst for the discussion. We are fortunate to have impressive panelists representing 6 world-class cities. Each of them will give compelling reasons for why they believe the seat they represent is the hottest. I am allowed a moderator's privilege of 10 minutes to give you a short introduction. I would like to focus on something very important. I can see there are many students there, so I feel at home. So a definition of the seats in international arbitration. Why is it so important? There are 2 reasons. Let me share with you the first one. When I was preparing this event, I asked ChatGPT, what is the difference between seat and venue? The answer was so confusing and so wrong that I decided to take things in my own hands. So what I'm going to share with you is not about ChatGPT. It's my own reflection. So as we all know, definitions of legal terminologies are very important because they have legal consequences. Definitions have legal consequences. Sometimes definitions even have implications on cost and time. In criminal law, definitions are referred to as qualification and can determine indictment, or if you are guilty, then you can be sentenced to jail by criminal courts based on definition. Fortunately, arbitration is not about criminal law. It's civil and commercial law. It is private and business law. So now, what is the best way? What is the best way to make sure that we are all aligned and have the same understanding of the seat in international arbitration? Because international arbitration does not sit well with a bad seat. And when it comes to the seat in international arbitration, the problem is that it is used interchangeably with similar notions such as site, or venue, or place, territory, jurisdiction. Lawyers also use specialized or fancy Latin expressions such as lex arbitri or lex ori to refer to the same. But in the interest of this debate, it occurred to me that an analogy can be the best way to explain a complex concept such as the seat. And the best analogy is what? Who can imagine what's the best analogy we can use? The best analogy is to compare the nationality of person to the nationality of the arbitration agreement. If you think about that, let us try to see. Because what is at stake is the recognition and enforcement of arbitral determination of awards. One of our clients asked me the following question: what is the finality, the use case, the utility of arbitration? Why should we go to arbitration? My answer was, it is having a decision issued by an arbitral tribunal anywhere in the world that can be recognized and enforced in most countries in the world easily, faster, and more cost-effectively than a court ruling. So knowing the nationality is critical, because In the context of arbitration, nationality refers to the legal identity or the origin of an arbitral award. Similar to individuals, there are two ways for an arbitration award to obtain nationality. Two ways. Who can guess the first one? How do you get your nationality? How? Okay, let's make it simple. So two ways. The first one is automatic nationality, and the second one is acquired nationality. Let me elaborate a little bit on that. So what is automatic nationality? Similar to the usury. The usury is the law of the land, the law of the place, the law of the soil, if I can translate literally from the Latin. So the usury determines the nationality in relation to the place where someone is born. Where are you born? Where? You, yes, where are you born?
I was born here in Thailand.
So you are Thai. You are Thai because you are born in Thailand or because your parents are Thai?
I might not see the best example here. I'm actually Asian.
Oh, okay. So you are Thai, you born a Thai passport. That is a good example. So nationality based on the jurisdiction or legal system in which the arbitration proceeding took place. This means that an award, listen to this, an award is considered to have the nationality of the country where the arbitration was conducted. Okay? This is very important because historically, or escaping or dismissing the jurisdiction of the court to resolve business dispute was illegal. It was not accepted. The famous doctrine of Ulster in English law was well established since 1856. And in this sentence that I quote from my book, there will be no Alsatia in England where the king's writs does not run. That is very important decision that was stated in 1856. As a matter of fact, court judgments are issued in the name of sovereign authorities or entities such as the king in Thailand, right? Her Majesty or His Majesty in the UK, the Republic in France or in Singapore, the states. If it's New York, in the state of New York, the chief executive, if it's Hong Kong. This is because they have imperial. What is the imperial? Imperial means the power of the sovereign, right? So later, when the expression of international trade, merchants seeking speed and efficiency in resolving dispute, literally invented the arbitration agreements. During those days, the arbitration agreement was truly an innovation. I would say a revolution. It was a paradigm shift. And we take arbitration agreement for granted today. The arbitration agreement was a legal construction with very unique principles for those who attend arbitration classes and my colleagues who teach arbitration. Those principles are the principle of autonomy, the principle of separability, competence of the arbitrator, and the power of an individual like you and me to decide who is right or wrong. In other words, a simple arbitration agreement created a whole ecosystem that generated obligation between the parties and the arbitrator, between the parties and professional organization, industry, for example, maritime arbitration or construction arbitration, government, arbitration laws and treaty, courts with the oversight power, endorsement, support, control. The arbitration agreement became the keystone that made an arbitration award possible. Of course, the arbitration agreement had to go through a process. But a question remains. Say the arbitrator, doesn't have imperium, meaning the power of the sovereign, the authority of the judge how to recognize and enforce an award in international arbitration. How? Who knows how this problem was resolved? Anybody knows? There was one convention. Just tell me the year. When was that year? Sorry? It was in 1937. In 1937, there was something called the Geneva Protocol, also known as the Convention on the Execution of Foreign Arbitral Award. Remember this, the Convention on the Execution of Foreign Arbitral Award. And the Geneva Protocol was replaced later by the New York Convention of 1958 on recognition and enforcement of arbitral award. Right? This is how the law was closed on automatic nationality for arbitral. So this is what I mean by automatic arbitration award with the nationality where of the place of the seat where the award was issued. So the key word here is foreign, meaning that if the awards have the nationality of any member state, it will be recognized and enforced in any other member state, provided that the reservation of commerciality and reciprocity do not apply. Now, let's look at the second way to acquire nationality. Nationality by naturalization, and arbitration can also acquire its nationality through a deliberate process using the mutual consent of the parties involved in the arbitration. And the party can expressly choose willfully the law or jurisdiction under which the arbitration agreement will be governed. In such cases, the award will have the nationality of the chosen law by the parties. Therefore, by analogy, we can apply the concept of naturalization to understand how an arbitration award can acquire its legal identity or nationality by choice with reference to what is called the lex arbitri. In conclusion, the state is the legal home of the arbitration, and it defines its legal status. It can also be referred to place or jurisdiction, but not venue. So when you hear seats, don't make the confusion with the venue. But sometimes seat and venue can be the same. An arbitration seated in Bangkok can have the venue localized in Singapore for practical reasons and still remain tied for recognition and enforcement purposes. Right. In recent years, and that brings us to this debate, in recent years, countries and regions around the world have started competing to be the seat of choice for commercial arbitration. It is literally a beauty contest to appear as the most desirable or hottest seat of international arbitration. So to start the battle royale about the hottest seat in international arbitration, we have representative of 6 cities: Bangkok, Singapore, Hong Kong, Paris, London, and New York. So now, ladies and gentlemen, take your seat. Hold onto your seat and fasten your seat belts, of course, without falling. Let me now introduce our esteemed panelists for the debate on the hottest seat in international arbitration. I would like to invite you to join me to give them a warm welcome. And I think first I will introduce the panelists, and then we'll go to a bit more to see who is starting, right? Okay, let me start with Amy Rose Igusa. Amy is not just a legal powerhouse, but also a true embodiment of the international spirit in international arbitration. At the head of Kudon and Partners Japan practice, she's been a guiding force for major Japanese corporations on a range of issues. With over 17 years of experience in complex commercial litigation and international arbitration across Asia, Amy has a unique dual profession. Amy is not just a lawyer. She's also a mental health therapist. So if you think too much and you have too much stress, talk to Amy. And moreover, Amy is a proud mother of 3 and a Hong Kong qualified lawyer who's thriving in a Thai law firm. Amy, we are eager to hear your insights later. Now, let's move to Ian Johnson. Ladies and gentlemen. Ian is a seasoned international arbitration specialist with vast experience spanning dispute resolution in various sectors, including insurance, hospitality, construction, energy, and finance. With impressive ranking and recognition, Ian claims to be the most neutral person on the panel due to his global exposure in London, many years in London, in Singapore, in Bangkok, and even a recent rendezvous in Paris. And yes, he loves pizza. Not just any pizza, New York style of pizza. Ian, your neutral perspective is eagerly anticipated and will be enjoyed. Next, we go to Tarachon of Far. I hope I pronounced correctly. Ladies and gentlemen, please give a warm brings a fresh perspective as an associate at the Piper, focusing on international arbitration, commercial litigation, and regulatory issues. With extensive experience across diverse sectors, including oil and gas, technology, and infrastructure, Far's expertise shines through in her work on arbitration under various rules in different jurisdictions. She is not only a legal enthusiast, but also a passionate international comparative law aficionado. Far, we can't wait to learn from your experience and insights. Next is Edward Tiravech, from Thailand. Edward is a partner of Project International Law Office. He boasts a 25 years of legal experience in Thailand. His lies in arbitration and alternative dispute resolution, a true international education, including stints at Washington University, in St. Louis and Sassoon School of Management, has molded his expertise. His New York law license and Thai mediator registration reflect his diverse legal career. Your wealth of knowledge promises valuable insight during these debates. Onwards to Assistant Professor Dr. Tidara Silafra Prirosu. Dr. Tidara is a full-time law professor at Chulalongkorn University. She is an eminent figure in the field, serving as Vice Dean for International Affairs and Director of Center for Dispute Resolution. Her influence spans academia and practice. In other words, Dr. Tidara wears many hats in the field of international law and international arbitration. Her experience as an arbitrator and expert add a unique dimension to our panel. Picking a spectrum of subjects from international commercial arbitration to jurisprudence, she brings a holistic perspective. She has a favorite quote, which is, "AIDS cannot drive out AIDS. Only love can." That is wonderful, beautiful quote. Last but not least, let's welcome Kefsani Sahasarun Singh of Canada. Senior associate at Herbert Smith, Free Hills, Bangkok. With a background in corporate M&A, capital market, he combines legal acumen with business insights. He's a trailblazer in enforcing cost award before their goals. Dan's expertise in shareholder dispute is commendable. His involvement in the Lawyers' Council of Thailand and Arbitration Institution shows his dedication to the legal community. And we are excited to hear your views. So, ladies and gentlemen, these accomplished professionals form our esteemed panel today. Are you ready for the debate? If you are ready, please make some noise. Okay, I've done now to the host, Ntalida, Olivia. What is next? Yes. Now we start with the floor. Who will start? Who will have the honor or the privilege to start first? Should we start? Let's do it. Go. So, yeah. You have the, can we call it a privilege or
No, me, I'm sorry.
or what? Okay, and the next one will be, I think I have to think, I don't make a confusion. So first is Yan.
No,
No, first,
just this part.
Far. Sorry. Far. And then
with second New York.
New York.
All right.
And then, all right. Sorry, sir.
Oh,
Next one. That's all. Next one. And of course, that's the last.
You mean not prepared?
So we are all set now. I will turn to our first speaker, London, where everything started, almost, in the history of arbitration law.
yeah.
So please, have 7 minutes to tell us the most compelling reason.
Hello.
You want to be on stage or you want to be seated?
I think I'll be seated.
Okay.
Need better partners.
All right, okay. So let's go to London with Bar and on the background of the beautiful iconic image of London there, and tell us the most compelling reason why you think that London is the hottest arbitration seat in the world. You have the floor.
Thank you, Roland, for your introduction. Just to save everyone's time, I'm going to get into it right away. Today, I'm going to share with you 3 main reasons why London is the most attractive seat of arbitration. Now, I believe that at the end, everyone gets to vote on your preferred choice of arbitration as well after listening to us. So I hope you pay your attention to what we'll be speaking on. Today I'm going to be sharing the main reasons that I mentioned on why London is the most attractive seat of arbitration based on my experience as counsel for London State arbitrations. Now, for background context, to those who are not really familiar with the seat of arbitration and generally London, currently London is seen as the leading seat of arbitration alongside Singapore, which Ian will be speaking about later. It is seen as a neutral, impartial jurisdiction with non-interventionist courts. and that's why London has long been a popular seat of arbitration. Even for parties having no connection with London whatsoever, and in my experience, I've visited Thai clients whose underlying contracts is governed by Thai law, but that shows that London as the shortest seat of arbitration as well. Now, the first reason why London is the most attractive seat of arbitration is really the English court's supportive approach over London seat of arbitrations. As Roland mentioned, the law of the seat governs many procedural aspects of arbitration, right? And as for London seat arbitrations, the England Arbitration Act 1996 governs the conduct of arbitration seat in London. It is really a piece of legislation that strives to enforce the parties' agreement to arbitrate with little scope of the English court's intervention. And what that means is that the English courts will only intervene where the tribunal is not acting effectively and where it is specifically permitted by the Arbitration Act. Now, the power of the court to intervene, as I mentioned, is particularly helpful in situations like when the tribunal, for example, when the tribunal is not yet constituted, and another example is where the tribunal lacks the power to make the required order, like for example, where no such power is conferred by the law of the seat or by the applicable arbitration rules. That's where the court's support and intervention comes in very handy to arbitration proceedings and facilitate the arbitration process. Now, to put into context, I'll give you some examples of the court's supportive power, which include things like the orders to secure attendance of witnesses. Now, since arbitration is a consensual dispute resolution process, the tribunal does not have any general power to make orders against third parties, right? And in that case, that means that the tribunal cannot order third parties, witnesses to either give evidence or to attend an arbitration hearing. In that case, for London seat arbitrations, the English Arbitration Act really confers the power of the court to, for example, secure the attendance of third-party witnesses or just witnesses in general by way of a written summons in the same way as for court proceedings. Now, if the court issues a summons to support the arbitration process and witnesses fail to comply with the written summons the court issued, they can be found in contempt of court, which is either punishable by a fine or by imprisonment. So this is one of the measures that the English court can use to support the arbitration process for London seat arbitration as well. And another example is the enforcement of the tribunal's peremptory orders. Now, if you're not familiar with peremptory orders, they are final orders or basically directions of the tribunal, which usually specify a time period for compliance. It is usually made following a failure by a party to comply with the tribunal's procedural orders, and those procedural orders can be things like the order for a party to provide security for costs or provide security for the future award. Now, if the defaulting party breaches the tribunal's peremptory orders, the English court can support the arbitration process and can support the tribunal by requiring the defaulting party to comply with the tribunal's peremptory orders. Now, I use the term support because the court's role is limited to supporting the tribunal. They're not there to split the arbitration process or reviewing or second guessing the tribunal's order. And I would highlight that in practice, this type of order is particularly helpful because the English court has sanctions that otherwise an arbitration tribunal does not have. And that's what can be seen where a continued breach of the orders by the defaulting party will be placed in contempt of court, which again is punishable by fine or imprisonment. So making it a very effective measure to force the uncooperative party to comply with the tribunal's order, making the arbitration process very effective and efficient as well. There are other support powers such as freezing injunctions and things like that.
See, that time is out. Thank you for that. So,
Yeah,
sure. That's what.
just to raise this very new issue of recently the Law Commission of England and Wales are proposing to amend the English Arbitration Act, which would affect how English seated arbitrations work. So that's a very new and a very welcome change as well. And just very briefly, I wanted to discuss this. One of the significant the most interesting change that they propose to amend the Arbitration Act is the inclusion of the rule to the effect that the law of the arbitration agreement is the law of the sea. And that's not been done anywhere else. It is really a welcome change because, as we know, there's been recent divergent decisions in the English courts and in the French courts with regard to what is the applicable law governing the arbitration agreement.
Oh, ladies and gentlemen, let's give a big round of applause for advocacy of London. A lot happened in London during the last 100 years, from 1856 to 1986. And that's interesting to follow. From London, let's go to New York. New York. What are your compelling reasons to bring us to New York?
Hello?
You can swap.
Yeah, I think like that. Have this magical power of wonderful privilege. I'd like to make my presentation, take a slightly different approach with my presentation. My presentation, I'm focused again on, I have three main reasons why New York City is the hottest seat in international arbitration, but they're not all exactly legal reasons. So let me go through those. I think the first reason for why New York is so hot is its sheer size, okay? Its sheer size. Number one. Number two is the litigious nature of American society. American society is very litigious, and as a result, there's plenty of precedents in New York. Another reason is that New York is unsurpassed as a common law jurisdiction. I think these three reasons are the main reasons why you should choose New York. In terms of size, New York City has a population of about 19 million people. That is the other jurisdictions that we're discussing today, other arbitral seats that we're talking about today, have about 1/3 to just over 1/2 of that population. And because of that sheer size, we're dealing with great diversity, a lot of diversity and a lot of choice when you pick New York as your arbitral seat. You have a wide range of choice, and that's something that needs to be considered by disputing parties when choosing an arbitral seat. Let's consider how New York benefits from its size. First of all, New York benefits in the fact that it has perhaps more arbitral institutions that disputing parties can choose from. It has at least 3 arbitral institutions, domestic ones, and another 2 international ones, including the ICC and CAIRB, which are the most popular arbitral institutions available right now. And it's very telling that the ICC and CAIRB would open up offices in New York City. I think it says quite a bit about the potential they see in New York City. So I think that's one point. Another thing is that New York offers more arbitration venues, perhaps than any of the other arbitral seats that we're dealing with. And we're talking about not just world-class hotels, which have business centers, but as well as dedicated arbitration centers, such as the New York International Arbitration Center as well, where they're purpose-built centers that provide for a venue for arbitration. Another benefit with New York City in terms of its size is the fact that you have a very wide selection of arbitrators that you can choose from, court reporters or secretaries of the tribunal, counselors, expert witnesses, and translators. And these people have very diverse backgrounds, very diverse nationalities, and speak a wide range of languages, and they're all resident in New York City, or maybe as far away as Boston, or perhaps DC. And it's very easy to reach New York by both rail, by train, basically by any means that you can possibly think of. Okay, so that's with regards to its size. With regards to another factor in favor of New York City is the fact that it's a very litigious society. America is arguably, not even arguably, I've looked it up on several websites, of the venues that we're dealing with today, or the countries we're dealing with today, New York is the most litigious society. And that is a very important part. It's even more litigious, believe it or not, than the UK, and certainly more than Singapore, Hong Kong, France, and Thailand. And the fact that its sheer size combined with the litigious nature of the society means that New York judges are very experienced in dealing with commercial disputes. And New York courts in particular are very experienced in dealing with and providing support for arbitrations. They're quite used to doing so, and they're very capable and very competent to do so when necessary. When there's an issue, perhaps attachments, preliminary injunctions, and other issues that may crop up that would require the participation of the court. The third reason is that New York is unsurpassed as a common law jurisdiction. Common law, as many of you probably know, benefits parties because it provides, first of all, the disputes can be settled oftentimes by judges without referring to statutes. So judges can make laws on the spot. And the fact that the decisions are often published and available online means that parties can study how a courts are likely to decide on any particular procedural issue, or even how a particular judge might decide on a particular issue. So New York is also unsurpassed again because of its size and because it has so much litigation. So again, in summary, New York has the benefit of its sheer size, the fact that it's part of a very litigious society, and the fact that it really is an unsurpassed common law jurisdiction. I think that's all I will have to say for now. I think I have some comments about some of the other jurisdictions and their weaknesses, but I think I'll wait for that right now.
You still have time?
Oh, I do.
Yes.
Time.
Okay,
one minute. Again, the benefit is of its size. London, Singapore are literally a fraction of the size of New York City, and therefore, while there are very good choices for arbitral seats, the level of resources available are simply not going to be as great. Singapore, in particular, really lacks that size, and it lacks that organic diversity that you would find in New York City. And while there's a lot of resident talent there, you're going to have to actually fly with a lot of people as well with Singapore. Hong Kong, it's part of China. It's part of China, and its political and even its legal system is now sometimes it bends a bit more towards the will of Beijing. And then, despite the promise of one country and two votes, Paris and Bangkok, wonderful jurisdictions, but then again, they're civil law jurisdictions, and there's some downsides to civil law. And then finally, that's basically it. I'll leave it at that. Actually.
Thank you so much, Bob. I think your briefing is very convincing, very vivid. I will leave it to the audience if they believe that the common law is better than the civil law system, because some don't agree with that, especially with the discovery procedures, which can be very costly. And okay, anyway, that is for the audience to decide. So now let's go to Paris.
Okay, thank you. I'm very different from Fa and also from Edward because of the fact that I'm not a French lawyer. I graduated from French law school, Toulouse, but I'm not anywhere near Paris. And I myself would, prefer Toulouse to Paris anyway. But because of the fact that I'm here for Paris, I will try my best to advocate for Paris. But if there is any mistakes, please feel free to discuss me after this and not hit me on the head on my mistakes. But anyway, I have no issues with London and New York. I think they're both great places. I've been there both. But for example, probably Paris is not as delicious as New York. I'm sure that from the picture of Paris behind me, it's a very wonderful city, and it has a lot to offer. I'll just advocate for Paris from three perspectives. One, as a venue. Second, as the capital of the law, as they claim. And the third, as the place of arbitration. So on the first part, I think everyone is probably agree with me that it's one of the most romantic cities in the world, Paris. There are a lot of offer, food, good transportation, where a wide range of cultures is a melting pot. Basically, we do have francophone people. They all speak French. Also, some do speak English as well. You have Chinese food in Paris. You have great ice cream, and that already sounds a good place to mediate and to arbitrate. So that's the first thing. We have a lot of cultures. We also have a lot to offer in terms of history as well. If we look back into the history of Paris, that ICC is headquartered in Paris. They have a hearing center in Paris, which you can see to the left, like this, which is wonderful when you arbitrate. So unlike New York, you have quite a little bit of dark places underground to arbitrate in terms of, no offense, but there are style to the city, but I think probably Paris offers differently. Another thing that I would like to mention is Paris is also ranked as one of the top 100 city destinations by Euromonitor. It will be hosting Olympic in 2024, so we know they have good facilities. Of course, they have, and also the location, because it's center of Europe. So there are a lot of, easy for European parties to travel to Paris. So of course, location is also the benefit. So moving on to the second point for Paris, because Paris, of course, is a home to civil jurisdiction. And civil law model for all places around the world, including Thailand, Bangkok. Maybe there are downsides to civil law, but also there are upsides for civil law as well. For example, we are pretty lean in terms of procedures. We are less costly. I think costs in New York and in England to do discovery, as mentioned by Roland, or in costs at least to make submissions. I think they're pretty high, pretty costly. And believe it or not, I just found that there is a campaign for Paris to be the capital of law. And also we have Arbitration Academy in Paris. We also have resources and network in Paris. As you know, all the big firms have a very good arbitration practice in Paris. So that also speaks of itself why Paris is very important for arbitration. We also have parisarbitration.com, which is a website by Paris. They explain why we should choose Paris as a seat. So I don't want to tell it all out here. Probably you can look it up in their website. There are a lot of compelling reasons why we should choose Paris as a seat. In terms of popularity, in the Queen Mary's survey, Paris ranked the 4th. Even though it drops from the 2nd place in 2020, still, they are very popular in some regions. For example, like in Europe or in the US, I think they're ranked pretty high. And even though sometimes they're ranked after London, but compared to London, this satisfactory rate is much higher than London actually, even though it was chosen as the second place. Moving back to the judicial seat perspective, I think it's very important to point out that Paris have a very innovative courts. They are one of the first country in the world who have arbitration acts, even before the Austrian model law. So we are pretty innovative. And we also just revised our act in 2021 not in an act, in our civil procedure code. So it's incorporated into our system without having to say that it's a separate statute or not. And as you may know, we also have a very interesting decisions. For example, like Bali or the one in Yukos case, we enforce award, even though it was set aside in other jurisdictions. So it's a testament of the fact that we are very pro-arbitration-friendly jurisdiction. And also we, apart from that, I think we also adapt to the new world by allowing e-signature in awards. We allow remote hearings, and we also have a lot of features. For example, like if you do not raise irregularities proceedings beforehand, you cannot just set aside the reason there are irregularities. So basically, it's just an express waiver, and that's included in the code. So all in all, I think Paris is a very, very good place for arbitration. Not only the fact that it's a legal place, but also a place where humans can settle the disputes. Thank you.
Thank you so much. Depends on Paris, and indeed also graduated from Paris, so I really relate to what you're saying. And actually, for those who don't speak French, it's very interesting the way the French language designed the seat. It's called the siège, as opposed to le lieu, which is the seat, literally, which is where you're sitting. I think the Thai also have the same difference. You have certainty and you have tina. Is that correct? That's almost the same. So it can be confusing, right? Indeed. But the battle between Paris and London is very old. They started a long time ago because apparently ICT would have been created in reaction to London. They wanted to take arbitration business from London. So that is the story. I don't know if you can validate it, but a long story of battle. So from Paris, shall we come back to Bangkok?
Thank you. A very good evening to everyone in this room and also at home, online, or from your office whatsoever. It's a great pleasure today for me to speak to you all here, and also a great pressure as well. Because if you look at the Queen Mary Survey 2021, Bangkok or Thailand or the seat is not even there, but all the rest of the representing one of the most popular cities in the world, especially London and also Singapore. You can look at that survey as well. However, I will do my best to represent Thailand. So I have the very first point that I like to make why Thailand is the hottest seat. To be hottest seat doesn't mean that I wouldn't focus on the accurate numbers of cases, but more on the temporal aspect of the issue because it's becoming hottest. Why? But the reason is that because if you follow the geopolitics or the news, there is a lot of sanctions imposed by the EU, including France, and also UK as well, US, and Singapore also imposed some sanctions against, of course, Russia. And as you may know, because of those sanctions, there increased a lot of number of the disputes concerning many sectors because Russia have a main role in several industrial sectors, especially energy, oil and gas, commodities, and many things. So the thing is, the point that I like to make is that why the number of the commercial dispute or other type of dispute is increasing following the sanction, but there are some limitations. on the use of certain seat of arbitration following those sanctions. For example, you might need to even becoming an arbitrator in those jurisdictions with or those seats which have the sanction in place. You might need to get some license as well or some approval. For example, if it's the case of London, you might to apply for the license of from the office of OFSI. Is the license you need might be otherwise you might be in trouble as well. You might be in the violation of the sanction law. It could have some criminal liability also. And for the case of US, you might have to apply for the license at the OFAC. And for Paris, you have to contact as well the office at I think the treasury of the France as well that you need to get the license. And also because Russia not just stand still, they impose some anti-sanction measures also, especially including the amendment of their commercial procedural code as well in I think in 2020, where they amend certain part of their law. I think it's a 248.1 and 248.2. The 248.1 rule is that the Russian court can have the exclusive jurisdiction over the case that involving the Russian party that that was subject to the sanction in those cases, so they can have the jurisdiction over this case, or in other words, the arbitration clause can be invalid basically. Because they feel why, you might ask why. The rationale for that is that they feel that because those sanctions can have some unfair advantage or some impediment for the Russian party to access to justice. And also there is another rule 248.2, I think. This one is also the case where the party can apply to the court to get the anti-suit injunction or basically anti-arbitration injunction. So basically, if you having the arbitration against the Russian parties, you might be subject to that anti-arbitration injunction, and your award might not be able to be enforced in Russia. So what to do then? The answer is very easy. You just try to find the seat of arbitration with the sanction neutral, and where in this room, our partner seems to be Hong Kong, right? But then Hong Kong also has their own problem with sanction as well. If you Google for 263 sanction, you will know that is another type of sanction that is imposed by the Chinese government that might restrict your choice of the counsel or even arbitrator. So there could be some issue of the public policy under the Article 5 of the New York Convention, especially 5.2b. And for the Russian party, they might invoke 5.1b for the inability to present their case. So either way can be the problem of enforcement of arbitral awards. So now why not consider Thailand? Because we cheaper, of course. If you put the certain amount of claims into the fee calculator on each of these rival arbitration centers located in other states, you will find so much different in the fee that we charge, especially if you go to the THAC website. THAC even offer the small claim rule as well, which is even cheaper. So that could save a lot in terms of the cost of arbitration, and in terms of the court. If you follow and update, the Thai court recently become very impressively arbitration friendly as well, especially the Supreme Administrative Court of Thailand. At least, although it's not yet like completely settled, but you follow like even the Hopewell case, the Supreme Administrative Court had a positive outcome in terms of the ruling regarding the Hopewell case, and also other Supreme Court cases as well. Even enforce the foreign arbitral award that come from Singapore in line with the Singapore court as well. Even when in that case the arbitration have been conducted under the expeditive procedure, which those only sole arbitrator, one arbitrator, which is not in line with the arbitration agreement. But the Thai court, the Thai Supreme Court last year already, enforce that decision. And last but not least, if you come to Thailand, we have the campaign Amazing Thailand. We are the most visited country, and also Thailand is globally ranked as the top destination for the digital nomad. In this case, I believe that because of the atmosphere, you might be able to even settle your case and actually go home with the consent award. So win-win solution as well.
Thank you very much, Nicola. You really pointed out some of the unfortunate aspects of international arbitration due to geopolitics and war implication. This is a bit sad. Yeah, we can say that. But anyway, at the end of the day, Thailand emerged as the country of the art of amicability. This is the most important. So from Thailand, let's go to Hong Kong.
Thank you. Well, it may be amazing Thailand, but Hong Kong is Asia's world city. So I'm here to represent Hong Kong today. As you can see from my outfit, I am committed to this debate. So why Hong Kong, right? I'm going to make this decision very easy for you. I have prepared some prompts to help you remember why Hong Kong should be the preferred seat of arbitration. And this is it. Can everyone see this? Hong Kong is number 1. Now, today I'm going to use this word one as an acronym to explain, so using each letter to explain the reason why Hong Kong is the preferred seat of arbitration. Now, the first letter in one is O, right? So what does O stand for? Oh, here we go. O stands for one country, two systems. Now, Edward cheekily referred to this in a negative way, but I am going to suggest to you that this is actually a very positive thing for Hong Kong. And the reason for this is because one country, two systems means that Hong Kong and mainland China have a very special relationship. And this is in the context of, arbitral seat. This is important because they have made an arrangement in 2019 called the Interim Measures Arrangement between Hong Kong and PRC, which means that Hong Kong is the only jurisdiction outside of mainland China where parties to arbitral proceedings would be able to apply to mainland courts for interim measures. So Hong Kong and PRC share this special relationship where it can really benefit arbitral parties when they're seeking interim measures in those two jurisdictions. So one country, two systems is actually a positive thing. The second letter in one, right? And what does N stand for? N stands for neutral or judicial independence. Okay, so O was one country, two systems, N is neutral or judicial independence. And the statistics here and the rankings actually is pretty amazing in terms of Hong Kong, because I looked up the World Economic Forum Judicial Independence Index, and the latest statistics I can find placed Hong Kong as 8th in the world. Now, not pointing fingers or criticizing anybody here, but let me just give you an example of the other countries that are represented here. Hong Kong is 8th, Singapore is 14th, US is 25th, Britain is 26th, France is 36th, and Thailand is 64th. Okay, so Hong Kong ranks the highest in terms of judicial independence according to the World Economic Forum. Now, why is that important? Of course, arbitration neutrality is very important. So when you're thinking about the seat of the arbitration, when procedure law is determined, then you cannot divorce neutrality and judicial independence from the seat. Of course, Hong Kong also has a very solid arbitration legislation in its arbitration ordinance, which was introduced in 2011. There are many key provisions in there which I don't have time to go into today, but very happy to discuss with you later. Arbitral awards are enforced by Hong Kong courts and in the mainland. So there's a special arrangement between Hong Kong and mainland China,
regarding enforcement of awards. And this was supplemented very recently in 2021, which allows post-award interim measures and also just removing any restrictions so that parties can make simultaneous application to Hong Kong and mainland courts for enforcement. So there are very positive developments in Hong Kong. Hong Kong courts are also very supportive of arbitration. It's known as a very pro-arbitration friendly jurisdiction. There have been many decisions in the last couple of years where Hong Kong courts have set aside applications for stay of proceedings and also just so in favor of arbitration. So the parties where they bring proceedings in the courts have set that aside and said, no, this should be going to arbitration. So interpreting contracts in favor of arbitration. Hong Kong also has a group of specialist judges that are responsible for dealing with arbitration-related cases for efficient disposal of arbitration cases. And their stance is to facilitate the arbitral process. They have made this very clear. Now, the last letter, of course, is E. Now, what does E stand for? Okay. Hong Kong, and you may know if you've ever visited Hong Kong, it's super efficient, and it's the same with arbitral proceedings as well. So Hong Kong is very innovative. They've introduced some latest legislation in relation to costs. Okay, so there was a mention of China being very cheap, but Hong Kong is very cost conscious too. So they have introduced third-party funding legislation in 2017, and the latest legislation that has come into place is the outcome-related fee structure for arbitration. So that means that they can look into conditional fee arrangements or damages-based agreements or hybrid damages-based agreements. So it gives the end user of arbitration a lot of options when it comes to costs, because of course our clients and customers that are using arbitration are very concerned about costs. So Hong Kong has addressed this and faced this. Now, HKIAC, of course, is also a very famous arbitral institution, amazing facilities, but it's also very diverse and inclusive. So I looked up some of the statistics here, and it says they made 159 arbitrator appointments, of which 27% were female, and 30% of those arbitrators had not previously been appointed by the HKIAC. So this means that HKIAC is always conscious about being diverse and being inclusive with their arbitrator appointments. And it's also very international in nature. They also have an online dispute resolution center in Hong Kong called eBram, which is purely online. So e-mediation, e-arbitration, e-negotiation, very impressive. Now, time out. So I just want to make one point and address the elephant in the room, and referred to by Edward earlier, is that yes, Hong Kong has its challenges. You're probably thinking, well, Hong Kong has protests, it's part of China, it's influenced by China. But you know what, as I mentioned earlier, I think what is perceived as Hong Kong's weakness can be converted into its strength. So whilst you may think, well, it's influenced by China and that might be a weakness, but actually turn that around and look at it as, well, they also have a special arrangement where interim measures can be enforced in both countries. It's got common law and civil law. So there are advantages to that relationship as well. Thank you.
Ladies and gentlemen, that was Amy Rose Igusa. Very impressive acronym one. And I hope there will be questions regarding, the intersection between common law and civil law in China. Because when you say arbitration in China, do you mean mainland China? Do you mean Hong Kong? Or do you mean Macau? That can be some kind of debate, arbitration in China. But the Chinese call mainland China differently from Hong Kong. Anyway, let's go to the last. Singapore, only 1 hour from Bangkok.
Thank you, Roland. I wish you hadn't said earlier that this was akin to a beauty contest, because we know who's going to lose here. For people watching at home, the camera is staying hands. I think, my arguments in favour of Singapore are going to be quite similar to me in that they're simple and relatively short The three C's are what come to mind when you're thinking about arbitration and what you should be considering. The first is convenience, the second is confidence, and the third one, the one that nobody's mentioned so far, is corruption. I think you came first. And in that perspective, you look at the Perceptions of Corruption Index that's published every year, and you will always see that Singapore is near the top. Now, we all, I think, would agree that in this room, we're all in favour of arbitration as a dispute resolution mechanism. So what we're all essentially here is to say is that you should be using arbitration, but what is the problem with arbitration and with certain seats is, of course, is the perception that they are not going to get a good decision from that seat. And sort of involved in that, of course, is the perceptions of corruption. Now, Singapore usually floats somewhere between number 1 and 5 every year in terms of perceptions of corruption index. I won't treat Hong Kong as part of China, and so for that reason, you almost make the top 10. You could be down out in Paris and London and in the 20s. If I had a prop for the USA, which would be 69, I would say, well, you know, if you think the list must be upside down, you turn it the other way around and it still says 69. And welcome to Bangkok. As much as I love you, you almost made the top 100.
Just perception.
And so for those reasons, you know, for a start, if you're looking at the International Arbitration Center and parties around the world, you want them to feel confident that they're getting a fair decision and that they're in a place where there isn't going to be too much influence from corruption. And for those reasons, Singapore stands out. So that's your first C, corruption. Your second C is confidence. Now, in terms of confidence, there's different aspects to that. One is the ease with which you can get foreign arbitrators to work in Singapore. So, Edward, I think you were saying one of the advantages of the USA and New York in particular is that you have this massive pool of arbitrators and people can bring them in. But people sometimes aren't confident to use arbitrators from the seat that they're going to if they're from another country. And in particular, Singapore makes that easy. They make it easy to bring in arbitrators. I think you know I think it's something like 64% of arbitrators who work in Singapore comes from another jurisdiction, because Singapore said, hey, if you want to see that the system is working and taking into account your needs and where you come from and your views and your cultures, then the best way is you bring one of your own arbitrators to the panel, and that's what happens particularly frequently. The other aspect of confidence, which we've all touched upon in terms of the different legal systems, but Singapore really takes its key, is the degree to which the legal system is pro-arbitration. Now, we can all talk about the benefits of the legal systems and how they work, but what Singapore has done particularly effectively to get to the position it has done is looked at New York, it's looked at London, it's looked at Hong Kong, it's looked everywhere else and seen what they've done well in their legislation, and they've stolen it, quite frankly. They've taken it and said, well, that works really well, we'll take that bit, but we don't like that bit, so we'll leave that bit out. Then they've reinforced it with the International Arbitration Act, they've reinforced it with the Domestic Arbitration Act, they've reinforced it with the number of arbitral tribunals that are also moving to Singapore. And they've then gone overboard essentially by getting a judiciary that is predisposed towards saying, well, once you have an arbitrator's decision, I am not going to overturn that for any shallow reason. You need to have a very good reason. And the courts have even recently had decisions where they said you can't kind of what they call come through the back door and try and use other bases for challenging this, these decisions. It needs to be a proper decision on the basis of law, and for the most part, they won't turn over decisions. We've even got situations now where I think everyone knows a case in India recently where the Indian courts said the various aspects of the Singapore arbitration have been enforced in terms of emergency arbitration, in terms of expedited procedures. So Singapore has respect around the world now, and I think you mentioned decisions in Hong Kong and also in Bangkok also being enforced here, and that is because of the people's trust in the system. So that's the first thing is corruption, the second one was confidence, the third one is convenience. Yes, Singapore is a relatively small city, but for anyone who drove here tonight, they would appreciate that. It is also a very good city. But the saying that says of Singapore, it's an easy place to like and it's a hard place to love. And that is a backhanded compliment. And what they mean is that when you get to Singapore, you can't say anything bad about it in terms of the way the city works, in terms of its connections, in terms of its hotels, in terms of the way that they are primed to be efficient. And that sort of moves through into the arbitration procedures. Getting a work visa for your arbitrators is easier there than it is anywhere else. Getting in and out for the purposes of doing arbitration is easier there than it is anywhere else. The efficiency of the system is built to say, we are a country that doesn't have particularly big natural resources or anything like that. We build essentially things so that people will come. Which was use a baseball analogy there for the American side, and you know that's essentially what it comes down to. Three very simple things. I'm not going to go into any great detail about the bits that we probably already know about in terms of the legislation, but it's just literally corruption, confidence, convenience. Those are the three reasons you come to Singapore.
Thank you so much, Jan. What is striking with Singapore is that, you know, Singapore is a relatively young country. It was created in almost 1965. That was the date of independence of Singapore. But in less than 2 generations, they were able to catch up in, you know, some leading countries in many aspects, especially in arbitration. But this is very common, at least. This is my I
mean, you know, I always used to say the biggest sort of example of what Singapore's all about is it has no oil, it has no natural resources, but it has the second biggest oil refinery in the world, because that's what Singapore does. It knows that its business centre attributes are what attract people there, and therefore it makes it the best place to do business and to do things. And arbitration is a very good example of how it does that.
That's part of what they call human capital, intellectual capital. Ladies and gentlemen, please join me in giving a very big applause to the panelists for brilliant presentation, preparing their respective jurisdictions, please. Now, next step. Antonina.
Question.
Yeah. Now we have the floor. The audience are the floor. You have any questions? I can see many questions. Do not hesitate to address any of the speakers. This is your moment.
Question?
Yeah, question and answer. Yeah, Vanina, please go ahead.
Hi, well done to all the speakers. This was a fantastic job, and it's going to be quite difficult to choose. Well, between the seat and the excellent speakers. Now, I have a question about Singapore. Recently, there's news about, well, Singapore is doing so well that they've implemented withholding tax for non-resident arbitrators of 10% who are coming in for arbitrations. Do you think that this is going to have an impact on arbitration seated in Singapore?
Thank you for that question. I mean, the rules and regulations in terms of being an arbitrator in Singapore are that you don't have to pay income tax on any income earned as an arbitrator in Singapore. So the imposition of the withholding tax, which I think is 10%.
Yes, 10%.
Is relatively small beer in terms of having to pay tax on income that you would have to in other jurisdictions. It also, I suspect, has a benefit in the sense that if you have reciprocal tax arrangements between two jurisdictions, in the past, if you weren't paying tax in Singapore, they would probably make you pay tax back in your home jurisdiction. Whereas now, if Singapore's kindly giving you 10% tax, you don't get tax on the other 90%. So no, it shouldn't have an effect, is my answer. Don't hold me to any of that.
The idea of paying tax in Singapore is something. Yeah. The idea to pay tax.
I think it's brilliant. You have to mention people tax rate. It's not like Dubai. I mean, tax is usually about 12%, somewhere like that. So it is low tax, but it's not no tax.
It's up to 20-something%, so it's on a scale.
All right.
More than Hong Kong.
I say Hong Kong is very low in tax, so it's better than
Have you seen Singapore or no more?
I wouldn't say it's a haven,
Yeah.
as I say, it's about 12%
All
normally.
right, good. Any other question, please? I think Minister, please give me the microphone to.
I know Singapore and Hong Kong are competitors, one watching the other. When Hong Kong does something, Singapore follows very closely. Now, Eagle-san mentioned about these damage-based fees. I heard that Singapore follows suit by adopting some law concerning, they call it conditional fee agreements, something like that, whereas practically something like no win, no fee, no win, no fee, or something like that. Is this has it come into existence now in Singapore?
My understanding is that they do allow certain types of conditional fee arrangements, so it is now allowed in sort of contrary to the old common law rules. The degree to which it's allowed is not quite as extensive as many other places, so the contingency fee type arrangement still, I believe, is not allowed. It is more, as you say, sort of no win, no fee to a degree, and then it's tapered. But I must admit, I'm not totally familiar with the degrees that they've allowed it. I just know that it is now acceptable when it wasn't previously.
Thank you for your question. Any question from the students in Hong Kong?
It is.
No. Yeah, go ahead.
Oh, thank you. I have a question regarding London-based arbitration. You mentioned that there's a change coming to the Arbitration Act, which is that the law of the sea is the law governing arbitration agreement. I think this is quite interesting. So I'm just wondering what impact would it have on the parties who choose to arbitrate in London, and is there any other jurisdiction that is considering this kind of change? Yeah, that's the question.
I think in terms of other jurisdictions, I've not noticed legislative change, but I've certainly noticed, for example, in Singapore, there's also a similar case where the court was asked to consider what is the applicable law governing the arbitration agreement when the law of the seat and the law governing the underlying contract is different, and where the parties does not include their agreement on the choice of law, the arbitration agreement, which is, well, in practice quite common, because usually in arbitration clause in institutional rules not including what's the party's agreement on their choice of law which governs the arbitration agreement. Now, in terms of the impact this would have, because really this change, this proposed amendment to the Arbitration Act and the inclusion of this rule really came from these two divergent positions from the English court and in the French court as well. And in that parallel proceedings relating to the same arbitration agreement and relating to the same arbitral award, I think, if I recall correctly, the French court has found that the law governing the law of the seat is the law governing the arbitration agreement, because in that case, the parties had chosen Paris as the seat of arbitration. Now, conversely, the English court has taken a different approach from the French court and even the Swedish court and Singapore court, because in that decision, the UK Supreme Court found that because the parties had chosen English law to govern the underlying agreement, the underlying Swedish contract, that they inferred from the parties' intention as the English law would govern the arbitration agreement as well. So that's led to the court's decision to determine the scope of the arbitration. Now, I think this change, as I said, or proposed amendment actually is a really welcome change, because you would effectively remove this ambiguity or uncertainty between different laws of the field, right? And in commercial sense, I mean, and or like arbitration users who's not very familiar with common law approaches, the fact that you would have a rule that states in the Arbitration Act itself provides, clarity, and you don't have to refer to like the court's decisions on this very issue. So I think it's a very, very helpful role to include in the Arbitration Act. So
yeah, if I can add a little bit to that, I think that because of the principle of separability of the arbitration agreement, which is detached from the underlying contract, the parties can decide, they can put in the agreement, they can choose the law that they consider as the law of the seat. That is very interesting. Now, that was I was explaining, how an arbitration award can acquire nationality automatically or by choice of the parties. So coming to Paris, France, I didn't see any of the panelists addressing the uniqueness of Paris arbitration law, because it started very early indeed in 1982, the decree.
Yes.
And then you have two systems of arbitration in France. You have domestic arbitration with its own laws, and you have international arbitration. But it's not just international arbitration, it has to be international commercial arbitration, and that becomes a big debate on what do we mean by international commercial arbitration. Other countries don't have that issue, but in France, can you elaborate a little bit on that?
And that's also the point where the New York Convention picked up. It defines international commercial arbitration in line with the French courts and also the French legislation. But anyway, I just want to jump back to what you mentioned about the separability issues. I also have issues about pronouncing this word. So this is it's effective actually that a French court is very reserved in terms of interference or trying to interfere into parties' intention. So I think this is a welcome change, and I agree with you that people should be agreed, at least agree on the basic principle of separability, and to make sure that the intention of the party is about the law governing the substantive contract is different to the law governing the agreement. Also, I want to respond as well, probably to the end, the corruption thing. I don't know whether Singapore, I haven't heard that Singapore courts have actually implement the issues of corruption in Singapore courts in relating to arbitration. The French court has a lot of court cases relating to setting aside arbitration awards when it comes to issues of arbitration. So we are not only speaking about it, we did it. So I think that's also a plus to us. And also pick up on the point about because you mentioned about the issue of law as well. So French court is very conservative in terms of coming back interfering on the question of law, unlike the English court, where you have the right to appeal on the question of law in the awards. And also for the US court, you even have the right of course to do the pre-arbitration review of jurisdiction of the tribunal. So I think those are like the stance where the Paris court is very reserved when it comes to interference. I think that's very welcoming.
Any other question? Yes.
I want to ask the CEO of Hong Kong, can you elaborate more on why the weakness of Hong Kong in protest, and that can be a strength to your state as well?
Okay. So what I was trying to communicate earlier was that yes, most people may think of Hong Kong recently with the protests that took place, and maybe the national security laws that have been enacted. That is a weakness of Hong Kong, and people may say that because Hong Kong is now part of China, the judiciary may be influenced by Chinese government, and so on and so forth. So that may be perceived as a weakness of Hong Kong. But I was trying to turn that around to say, okay, well, what about the strength of that relationship? So as I mentioned earlier, Hong Kong and PRC, because they have this one country, two systems policy, they can have these special arrangements in place where, as I mentioned, Hong Kong and China can have these interim measures. So for arbitral proceedings, you could apply, if it's a Hong Kong seated arbitration, you can apply for interim measures in the mainland courts. And Hong Kong is the only jurisdiction outside of mainland China that can do that. So what I was trying to emphasize was that, okay, that relationship between China and Hong Kong could be a positive thing in the context of arbitration.
Thank you for the question and thanks again for the answer. I think we have some questions online. Can we take a few questions online? Somebody can read the question, which is highlighted for me, please.
I think neither 1 nor 3C nor even Eiffel Tower does much in arbitration. What matters if fair, reasonable justice, recognition and enforcement, efficiency and confidentiality without distortion in the relationship between the parties. Could this panel unanimously agree in one place? I still have trouble understanding the question, but anyone would like to pick that up? I think I do agree that fair and reasonable justice is required, as Amy mentioned about the judicial independence. I think that's very important, and also in terms of recognition and enforcement. I think that's also fair. We also mentioned those things. Efficiency, I think Amy has a lot to say about efficiency in terms of I also agree with Amy as well that because made submissions before Hong Kong court before. And they're very, very efficient, very quick, and the quality of decisions are pretty straightforward. I mean, like straightforward in a way, very lean, understandable, and implementable, and that's very important, I think.
Okay, thank you, Jasari. And next question. Can you read for us?
What is the hot seat in the jurisdiction? The seat is not stated in the arbitration clause. Okay. I assume that the question is, what is the hot seat if the seat is not mentioned in the arbitration clause?
What will determine the seat if the parties don't put it in the arbitration agreement?
Yes, exactly.
I think that's why we're here. Try to help you, persuade you as to which seat should be included in the agreement. Anyone have any other comments?
I think that we have to probably solve that by the rules, right? Some rules to have defaulted mode on choosing the seat, on issues regarding the seat and probably the connections between parties and also to the particular jurisdiction as well. So I think all these things have to be combined together and probably on a case by case basis. I assume.
I'm not sure if I understand the question correctly, but I guess they asked what if the arbitration agreement silent on the choice of the seat. I think from my experience, there are kind of still inconsistent approaches taken by different jurisdictions as well. Some jurisdictions, I can't remember the detail. I remember roughly that Japanese court took a different approach from the English court, something like that. And there are several ways to imply the party choice of the seat as well. Remember for sure that one of the approach is that sometimes they use the law of the governing law of the substantive, the substantive governing law of the contract as well. But there could be some other implied choice of the seat also, depending on relevant circumstances of the case, could be other criteria as well. And as I said, each jurisdiction have kind of their own approach that might not be common. Okay, that's it.
Would like to add something?
Actually, no, I have nothing to add to that. I think that both of those comments are directly on point. It really would depend on the facts and circumstances of the underlying agreements. We really have to consider what law applies to the underlying contract. And perhaps we could have then apply that same law to the arbitral rules of that law to the arbitration clause itself as well. But if you've gotten to that point, you've gotten, with all due respect to the question, you've gotten kind of sloppy. I mean, that's really something that you really should be able to get right away. I mean, you really should state where the arbitration seat is. Also, the question makes me to ask a question back. Are you talking about an ad hoc arbitration, or are you talking about an institutional arbitration? And it sounds like by just the nature of the question, I could actually see a contract if it says, if the parties have a dispute, it'll be settled by arbitration, that's it. And then we have to also consider whether we're gonna apply ad hoc arbitration rules as well, and whether that necessarily then means that the UNCITRAL rules will then apply. So we have to consider a bunch of things, but I think I agree with what my esteemed colleagues have said as well, and I just build on that by asking these additional questions and points.
That's why drafting the arbitration agreement is very important. I remember a few years ago, Dr. Vanilla organized a seminar on the pathological arbitration clause. You remember that was very, very important, very interesting. And you served at the ICC court for many years. I think the ICC has an article, maybe Article 14 of the rules, that say if the parties fail to write or to indicate the seat, the ICC will step in to, is that correct? I'm not sure if I remember well.
Indicate in the institutional rules.
All right, I see. Yes,
Can I make some comments on this? Yes, I think under Article 20.
We would like to know you better. Can you introduce yourself so that the audience can know? Yes, for the young.
Who is a fellow of the Chartered Institute of Arbitrators and a very senior and recognized arbitrator in Thailand.
Thank you very much for the contribution.
Right, on that point, I believe Article 20 of the model law specifies that the seat, in the absence of the seat of arbitration in the arbitration clause, it's the duty of the tribunal to determine. And the tribunal will have to decide the seat based on the conflicts of law rule. It could be implied choice, it could be express choice of parties, it could be
connecting elements of the original.
Like that, yeah. And in Thailand, we Article Section 26 of the Thai Arbitration Act is just a mirror image of the Article 20 of the model law. Okay.
Thank you so much. Yeah. Any other comment or any other question, or we can move to the vote? Oh,
Two questions.
One of the hot topics in consideration of the hot seat right now has to do with Russian sanctions and CIS disputes. And this is unfortunate for the US and for London and Paris that due to sanctions, the LCIA has lost a big chunk of disputes, which were predominantly handled at the LCIA court, and they have migrated to Asia. The SIAC, HKIAC. Now, recently I have heard that Hong Kong has faced a recent challenge with one of the cases having issues with enforcement in Russia. Now, what are the thoughts of the panelists advocating for Asia and whether or not this is an opportunity for Thailand, given that it's the #2 country for Russia investments at the moment? This is something we should be promoting.
Right, yeah. Yeah, I think that is a great opportunity because if I have to speak for Thailand as a budget lead, I would rather focus on this issue that I can just kind of underline all the colleagues like prefer seat here, because as I said, there are a number of sanction restrictions. It's not just about the kind of the public policy issues with the enforcement. There is also some of the countermeasure of the Russian, for example, as I said, the amendment of the Commercial Procedure Code 248.1 and 248.2. That could affect the arbitration seated in those sanctioning countries as well. So, and also even the transfer of payments, there could be some issue as well. A lot of things that you have to do extra. I'm not saying that it's not possible, but you have to take a lot of extra steps. You have to perform a lot of due diligence as well. You have to even have an expert, sanction expert in your team. A lot of webinars these days about international arbitration talking about the sanction issue. Because you have to be careful, because if you make a mistake, this means that you can be subject to even criminal liability. So that's why I think to make it easier or simpler for you, just try to consider the sanction neutral seat as well, such as Thailand. And Thailand, I don't want to say because we kind of have a good relationship with Russia for a certain degree, but at the same time we are friends to Ukraine as well, I have to say, which is neutral. So with the fact that we don't have those type of sanction laws, it's not going to be part of the public policy at least of Thailand. And that one, I think a lot of other like fairly law as well that we amended, like in the 2019 amendment as well, we allow the foreign arbitrators to perform their duties in the arbitration proceedings in Thailand. So even those foreign clients come to Thailand, they can still have a choice of foreign arbitrators under that amendment. And those foreign arbitrators also allowed to have the smart visa as well, which have a lot of the privilege even apply to their spouses. So I think with the legal infrastructure these days, including the recent decision of certain judicial decisions in Thailand, which are more and more arbitration friendly. If you update, I mean, don't get stuck with the the perception in the past. Change a lot. Even some article, I think I come across some article written by Dr. Vanina as well about even the ex parte case. Thai court also enforced because of the certain circumstances allow. Even against the Thai party, Thai court still enforce in favor of the foreign party. So there are a lot of new development. I think that Thailand could have a great opportunity for the following the case of Russian sanctions. And as I said, in Hong Kong, although they're not really the sanctioning region or country, but there are still some other type of sanction that is imposed by China, the 263 thing as well, and also the national security law that is the issue. Even one of the high-profile case, the gold mining case in Thailand also moved from SKIC to SIAC as well. So there are many international environments that I think it might be the time that Thailand have to take the chance seriously, even have some marketing to attract some of the sanction-related clients or parties. So I think if we take it seriously, Thailand could have some of the great opportunity here also.
As far as the sanctions are concerned, according to some academics, sanctions are unilateral decision made by sovereign countries and is not in according to international law, which require an agreement between countries. And that's why maybe there's a reaction. But now with the BRICS countries, some countries decided that what is happening is not proper according to what we know as international law. And they want to create their own system of payment through the BRICS country, Brazil, Russia, India, and South Africa. And this is a movement. So we can see a shift, a movement right now between different blocks of the world, where countries that believe they can take the sanction, and others say it's not fair. We need to create a different system. So it's not anymore really law. We're not talking about international law, but we're talking about geopolitics and other things that unfortunately are impacting international arbitration. So
we were saying before we came into the room, we were talking about where some people see risk, other people see opportunity. But I think where we need to be careful is just not see the opportunity and be blind to the risk. If you're starting to side with BRICS countries, then are you alienating yourself from the others? And so there needs to be a balance in these kind of considerations rather than thinking pure opportunity. You need to bear in mind the risk that you may alienate yourself from other countries.
All right. Is second question?
Well, this is just the final comment, at least from me, is that whatever seat you decide and whatever happens, if your award is set aside, you can always go and force it in Paris.
All right. We have the pleasure to have Dr. Niti here.
Yeah.
We would like to say something. You is a well-known academic specialist.
Difficult for me to choose
where to be seated for the arbitration for real. But I think it's a great opportunity to learn that when the times come, you can give a reason why it should be in Hong Kong, why it should be in Thailand. Thank you for the speaker.
Thank you, Dr. Niti. I see the lady over there sitting and looking at the panel, and I can see one or two questions in her eyes. Yeah. Am I right? No, okay.
One more question.
Okay, yeah.
More questions from Azit Beth, FCAIRB India. His question is, what could national courts do to make their jurisdiction attractive as a hot seat?
That's good. Fine, okay.
Okay, I can talk about this. This is something that I also raised. Something that the national courts can do to make the seat more attractive, I think also is supporting the arbitration process in the same way, because people often think that litigation process, the court has the power, as I give an example, to make orders against third party or like freezing injunctions against third parties or things like peremptory orders, right? So those are the kind of things that the national court can do to support the arbitration process. Because when an interested party in the arbitration wants to call in with third party witnesses, and obviously the tribunal does not have the power to do that, then in that case the court could come in and support the arbitration process in the same way as London the arbitration provides.
Just to follow it a bit, I think, from my practice as practically I think the right thing to do is to try to strike a balance between endorsing arbitration and filtering, those irregularities of proceedings. I think that's a fine line to do. Sometimes it's very hard. That's the reason why Paris is also known to be the place where you can go for enforcement. I think that's the go-to place for enforcement nowadays. And also because of from my practice in Thai courts, when I think the most important thing is when you make open submissions to the court and how the court looks at you and whether he tries to follow your arguments. Because sometimes when I go to the local courts elsewhere outside of Bangkok, enforce an arbitration award, the court probably sometimes say, I don't have the ability to use the Arbitration Act. I don't know how to use it. Please educate me. At least we go through it together, and at the end I can enforce it successfully until up to the Supreme Court. So when it's not about my experience, it's about open-minded, trying to strike a balance, trying to trust the process, and trying to honor the agreement between parties.
Yeah.
I think Hong Kong is a really good example of this, obviously. As I mentioned earlier, the Hong Kong courts have been very pro-arbitration. So I think being very open about that and making statements openly about how they are arbitration friendly, how they assist with the enforcement of arbitral awards is important. And also, as I mentioned earlier, Hong Kong courts have specialist judges that hear arbitration. They're very experienced and have the expertise, and therefore it ties into the efficient disposal of arbitration cases. So I think national courts in certain jurisdictions can look to Hong Kong, and to be fair to Singapore as well, to really see how the national courts can support arbitration.
Yeah, thank you for this question. I think even before the court can support arbitration, you need a law. You need a legal framework that allows the courts to act in that respect, supporting the procedure when there is problem, taking interim measures, because as we said at the beginning, arbitrators don't have the period, they don't have the power, the authority, and that they need to go to the court, to the judge, to request for the support that create an ecosystem of collaboration between arbitration and the judges. And what I saw when I was in Paris is even before the law, you need policy, vision. So vision and policy come first. Then you have the law, that will be the framework, and then you have the judiciary that can do the work. And that is exactly what's in that routine. You have those who saw it coming, policy, law, and then the judges can do what they want. Any just in my comment?
The only thing I was going to add is this, I think someone earlier mentioned things about expense, and obviously when it comes to Singapore, it's an expensive place, but when it comes to arbitration, you get what you pay for. And so whatever you're doing, whatever you want your courts to support, it's got to be a complex process to a degree to get the simplicity that you need. You can't just go to, a judicial body in a particular country and say, these make arbitration more attractive. You, as said by other people, you really need the support of the entire legislature to put the things in place that will achieve that.
I just like to add, as I said, that if you follow with the recent development, there are some statements that Amy mentioned as well that the Thai government made. For example, some of their decisions delivered by the Supreme Administrative Court also say that the court tried to limit the role in scrutinizing the arbitral awards. There are some cases that the court also expressly upheld the enforcement of arbitral awards, despite the fact that the arbitrator has incorrectly applied the law, but on the condition that that law is not relating to the public policy matters. So that statement that we want to hear more. However, as I listen to my colleague as well, I agree that needs to strike the right balance and needs to remain neutral. That is the whole point why we have the New York Convention. So I personally am not sensitive to the negative perception that much, because if there are some real cause for the court to refuse enforcement of arbitral awards in the name of justice for the other party, if there are some serious irregularities of the procedures, I think the court have to enforce, even it's the outcome gonna be 10 out of 10 cases that gonna be refused, for enforcement. They have to do that because that is in the name of justice, as I say. And on last point on the issue of sanction as well, I like to share with you about the French Court of Appeal as well. They're very arbitration friendly also in a sense, because they try to say that, but that is the sanction in relation, the US sanction against Iran. The French Court of Appeals try to say that they refuse to not enforce the arbitral awards following the US sanction on Iran, because they said that kind of just foreign policy and unilateral sanction is not fundamental enough. If you compare the French court give the distinction between the unilateral sanction imposed by the US versus the EU and the UN sanction, which is more fundamental and international. So that just to add as well that you don't have to be, because today I applied to speak on behalf of Thailand and I need to talk about the sanction. But if I went, I would be happy to say that that's still not always the case, that it's going to be problem with public policy matter, the issue of sanction, depending on the court analysis as well.
Okay, any other comments? Otherwise, we go to the conclusion of the.
We have one more.
That is one more question.
Does competence principle influence the seat of arbitration?
That's competence. Everybody knows what is competence here. It's found German. No? Competence. How do you pronounce it, by the way? All right. Yes, so.
Well,
you have to do that.
Competency in German. Well, the principle of competence is the principle that give power to the tribunal to decide its own power. That's all. Decide its own jurisdiction. That's all.
Yeah. Go ahead.
I checked before. I think all the seats here, we follow the competence rule for the tribunal in each jurisdiction determine their interest.
Absolutely. This is a very important principle of international arbitration that is embraced by all laws. Also the usage from the law, everyone, means that the arbitral tribunal has the power to decide on its own jurisdiction and post competence. And that is principles that are adopted universally today.
I just want to chip in a bit on that, because I'm representing Paris, is that compétence de la compétence. But because of the fact that, I do have experience, litigating with my Singapore colleagues before Singapore court, in the SICC case, the Singapore International Commercial Court. I think it's very impressive the way they're trying to preserve or trying to uphold that particular principle, because even there are irregularities involving jurisdiction, the Singapore court trying to stay away from that. And in terms of that, I think you get a very quality decisions by the court. Adding into that, I think Singapore is doing very good in trying to having specialized courts for international arbitration, and that particular international element is, actually, stands out from the world. That also applies to the Paris Court as well, because we have specialized judges, which decide specialized issues on arbitration or on international and cross-border issues, which can be different from national or domestic issues. And I think, when you get a very quality decisions with a very low fee, like in Singapore, compared to other jurisdictions, sometimes you even have law plans deciding your case in Singapore, and compared to English court, you have to go to English court and spend a lot of money trying to get a quality decision. I think that's why Singapore stands out for me, at least. Yeah.
Great. Yeah.
Just probably adding that if it linked to the seat, I think that although the arbitrator have the competence to determine their own jurisdiction, but doesn't mean that every time the court at the seat of arbitration will agree with them. For example, there are some cases in the Singapore courts as well that the court say that the arbitrator basically make a wrong decision on their competence as well. It shouldn't have been the Macau or the law of that is the or Chinese law is the seat of arbitration, but it shouldn't be Singapore or something like that. So just to add that the seat have some connection with the competence, and even as I said in the case of the sanction, the competence principle can be limited by the Russian law as well. As I said, they can issue the anti-arbitration, but it's just to have the main problem would happen only if you have to enforce the award in Russia. So to add.
All right, we are running out of time now. And well, if there are no more questions, no more comments, maybe we can consider that the debate is concluded. We reached the conclusion, and I'd like you to join me again to give a warm, applause and encouragement to our panelists. Thank you so much, everyone. It's time for voting. So we have different categories. The first one is the most preferred seats. So how do we proceed for the vote? How do we proceed? You just raise your hands. Okay. So we start with London. In the order of the presentation of the panelists. Okay, so let's start with London. Your reaction. We want to hear some noise, just, yeah. All right. After London, we go to New York. New York, how do you react to New York? How do you rate the game of course? But you raise the hand?
Yes.
Okay, so all right. So Talila suggests you raise your hand. So let's start again. London, raise your hand. How many? Okay. New York. New York?
Looking to vote? 2 votes.
Paris. Ville d'arbitrage. Okay. Bangkok, Kunta. Okay,
No one more.
all right. Oh, we go doing all this, right? Okay,
664. Who's the winner?
Singapore.
Yes.
Oh. Singapore. All right. Singapore. Congratulations. You're very consistent, huh? Ranking and even the THC debate. Congratulations. So the next category is number 1, up and running. No, sorry, up and coming seats. Number 1, up and coming seats.
You don't have to do the poll. Oh, yeah, you don't have it in just one in person, you do the virtual.
Oh, okay.
It's one category.
Yep.
It's only one category of the virtual.
Yep.
We can do in-person voting for the next 2 sessions.
For the next 2, so we have number 1, up and coming seats.
Yes, we can vote here in the room.
Yeah, we can vote in the room. Who think number 1, up and coming seats? The seat of the future.
Start with London.
London? Oh, seat of the past.
Yeah.
New York?
Anybody? I think New York.
Hong Kong. Okay, see that Hong Kong won this. And it's of course Singapore, we already won the first one, already out. Okay, next one. The seat with the most potential. The seat with the most potential. London. New York.
So I see something.
Potential.
Yeah, open offices there.
Paris. Bangkok. Hong Kong. 2, 3. And Singapore already, you are off. That's it. And I would like to give the floor to Vanina, because she's the organizer and she put a lot of effort and energy in this event. And we really want to give her credit to close this, say the last one. And so many things are happening in her life. She'll be leaving Bangkok very soon to Singapore. And we would like to say a few words, Vanina, to close this event.
Thank you very much, Roland, and thank you to all the speakers. I think all we can say today is really the winner is arbitration. And so I would like to thank all of you because you being here today is a great sign for the future of arbitration in Thailand. So let's keep up this momentum. And of course, it wouldn't be a completion of our event if I do not promote the Chartered Institute of Arbitrators. So if you are not yet a member, the Chartered Institute of Arbitrators is an international nonprofit organization that is a charity registered in London. And this kind of event is exactly what we do. We promote education on arbitration and ADR, and we are an organization that is dedicated to training. We are set to organize a fast track route to fellowship, Kun Suit being one of our very senior fellow. And one of the benefits of being a fellow is an easier way. It's not a guarantee of being empaneled in many of the key institutions that we talked about today. So if you're interested in becoming a member of the Chartered Institute of Arbitrators, we have some new members today, Tanida from THAC, who helped organize the event, as well as Burima from MDD. So welcome to our new members. And let's enjoy drinks for those who are in here. And also, there will be a special book signing by our very own author, Roland. So if you have any questions on the seat of arbitration, you can ask him. And apparently it's very worthy, Bitcoin-wise. So you can ask him all about that. And thank you again. And let's keep the momentum going on arbitration. Thank you.
We have a last surprise. This surprise. So can you put this slide on the screen? It's surprise. Marina doesn't go. And finally that go home as well. All right. I have developed a new passion, which is writing, besides being a lawyer, of course, focusing on international arbitration. And the City's King is the one I have published recently. If you want to buy one, actually, the book is published for fundraising because I run a foundation, so we do some activities. My next book is book for peace. Conflict resolution in the kingdom of animals. The lion, the elephant, and the owl. So they are fighting, lion and elephant are fighting for the habitats. Sorry? And they go to the owl because the dispute are the arbitrator. I mean, you see, and that is a book. The book is completed already. Now we're working with the illustrator so that it can be for the kids. If anybody is interested by this kind of project, please reach out to me and we can make, bring to the new generation because the kids are the future of dispute resolution. So I just want to share this with you. So this is my new project. Thank you very much.